strings on them.
So it would be nice to have a copy for yourself.
Yes,
Right. If you know any matter of union of professional foster carers, and certification officer and others, part-time.
sorry about the late start, Mr. Cooper. I have to say this before each session, but we'll try and do better. Yeah.
My Lord, the issue I'm about to move on to is the question of interference. under Article 11. I can take this relatively quickly.
Yes.
My Lord Hendy took you to the Pharmacists Defence Association Union case at tab 51 of the bundle. If I could just ask your Lordships to turn that up again.
Yes, just give me one moment. Sorry about So that's volume 3, isn't it?
2.
2, yes, right towards the back of volume 2.
Yeah.
And within my Lord Justice Underhill's judgment in that case, paragraphs 54 and 55 are the most important for our purposes.
Yeah.
In those paragraphs, my Lord set out a paragraph 54 that in that case the restriction in issue was one concerned with an element that the European Court has held to be an essential element of protection under Article 11 in respect to trade union rights, namely collective bargaining. And but your Lordship spelt out the obvious that doesn't necessarily mean that there are particular rights that need to be conferred in all circumstances. But then at paragraph 55, your Lordship says, applying that conclusion to this case, if the PDAU can demonstrate that the inhibition which paragraph 35, Schedule A1, imposes on what would otherwise be its right to seek compulsory collective bargaining under Schedule A1 is unjustifiable, that would give rise to a breach. And your Lordship then went on to examine whether justification was made out. Lord Hendy also relied on the remark at the top of the second column on page 1641, starting at the bottom of the previous column, paragraph 62, that if it were necessary, invoke the principles applicable under section 3 of the 1998 Act, since if derecognition under Part 6 were not available, there would, in my view, be a breach of Article 11. My Lord, it seems to me your Lordship will know better than I that it was an essential part of your Lordship's reasoning to get to the issue of justification, that the restriction in that case required in justification and was therefore a breach of Article 11.1. So the principle that seems to underlie that does seem to be that if there is a restriction on an aspect of the domestic regime which applies in a particular case but not more generally, then that will need to be justified. You reach the justification stage under Article 11.2. A similar process of reasoning appears in the judgment of the Court of Appeal in Vining, on which Lord Hendy also relied. Your Lordship's reference, it's at tab 54.
Yes, I seem to think in that case we were basically following PDAU, weren't we?
Yes, and it's paragraph 64 of that case. So, my Lord, that seems to be the position. Mr. Justice Supperston said something different in the Concordant case and also in the Deliveroo case. I'm not going to turn to them for your Lordship's references, that they're at tabs 62 and 63 of the authorities bundle. But unless your Lordships invite me to develop this point more fully, it seems to me that the process of reasoning in the pharmacist case and in Vining is decisions of this court, binding on this court, in respect of which the principle I've sought to summarise is part of the essential reasoning in the case. So, for present purposes, without prejudice to anything that might be argued in other cases, or indeed, if Mr. Collins wishes to take a tougher line or a different line from me, I'll stop him doing that. But for present purposes, I am prepared to proceed on the basis that if there is a restriction on the normal regime that would apply, at least in respect of an element which is an essential element of protection under Article 11 as identified by the European Court, human rights, then you reach the justification stage under Article 11.2. And so when you turn to this case, the possible distinction is that based on the extensive analysis and exchanges that your lordships and I engaged in yesterday about what the actual implications of the point at issue in this case are, that is not a point which in itself goes to an essential element under Article 11. So if all we are arguing about in this case is getting out of the starting blocks for the purposes of getting a certificate of independence, then that of itself is not an existential or essential element of protection under Article 11. Down the line, if and when we get, not we, but in another case, parties were to get to the arguments that arise in respect to the substantive rights, then collective bargaining is obviously going to be an important one and is going to engage the same questions that arose under the PDAU case and Vining. So that's the possible distinction in this case. The analysis that we went through yesterday leads us to the position that in this case, based on the way it's been brought, the way it's been formulated, and what your lordships are actually asked to decide, all we are talking about is listing for very limited purposes with substantive arguments on the other rights reserved to another occasion. On the basis of that analysis, I think the position we reached was, as I put it, it's not nothing, but it's almost nothing that we're arguing about. We are only arguing about getting a certificate of independence, which still leaves the material arguments the same when you get to the substantive rights, and we are arguing about some of the consequential administrative and internal regulation of unions, which are at best double-edged. So might in some cases be regarded as benefits, but in others might be regarded as restrictions, obligations, or red tape. So if that's all we're arguing about, it may not reach the same level as being a restriction that requires justification, because it doesn't go to an essential aspect of Article 11.
Can I just make sure I've understood? I'm not trying to query it, I'm just to make sure I've got the framework of analysis right. If you don't get listed, you can't get a certificate of independence. You cannot get any of the rights which are contingent either upon that or upon you being a worker. So if you like, there's a series of stages or steps. Step one, which is purely and simply listing, is only the first of a number of steps. And you say that because it is only number one and there are other steps, that doesn't take you into Article 11 territory. And it's the fact that it's the first of a series of steps that would, say, take you towards collective bargaining at the end of the day, a number of steps down the line.
Partly, yes. My point is this. If listing presented was not only a legal step along the way, a sort of a requirement in the overall test you ultimately have to apply to get collective bargaining, but were also a practical barrier to getting to the arguing about collective bargaining. So if there were no way you could get before the CAC or other court to deal with the substantive question of whether you can get collective bargaining, then we would be arguing about much more here. But because we are only arguing about getting listed and then getting a certificate of independence and then going to the CAC and still having the arguments about whether workers should be read down for the purposes of Schedule A1 as well as just listing, because that's all we're talking about. The substantive arguments aren't any different when you get to that point. the only advantage to the appellant of getting listing now is the recruiting sergeant point, that it may help with the practical steps of getting more members. And
so is this really another way of putting materiality? And you say that the
Yeah.
legal impediment doesn't matter here because it can, in practice, be circumvented,
yes,
which is another way of saying you don't need to have listing in order to get, you would say, sufficient rights, access to employment negotiation platforms and so on and so forth.
yes.
It really is another way of putting materiality.
Yes, it's the point I was going at length through yesterday,
Right, okay.
now being prayed in aid on the question of interference.
Okay, I understand. Thank you very much.
My Lords, unless I can assist your Lordships further on interference, I'm going to move to Article 14 and other status and analogous situation. And I preface everything I say on this by recognising, and as Lady Black does in the Stott case, see paragraph 43 at page 1880 of your Lordship's bundle. I don't ask you to turn it up. Recognising that the questions of other status, analogous situation, and justification very often bleed together in the way the European Court approaches these questions, and indeed in some of the domestic cases. And some of the factors are obviously relevant at each stage of the inquiry, even if it's logically and formally a set of distinct questions.
I'm sorry to give you two questions before we even start. Can I just ask by way of clarification, is any part of your analysis dependent on the word status? The reason I ask that is because the French version, which is equally valid, of course, just says all other situations, and it has a slightly different meaning.
It does, and the jurisprudence has noted that phrase as a basis for giving a wide interpretation to the phrase other status. I'm not going to be submitting anything to your Lordship that relies on the specific dictionary definition of status in English.
Thank you.
So on the question of other status, again, I start with an acknowledgement that your Lordships also expressed yesterday, I think, that it is pretty difficult to discern a rational set of criteria for determining what is and isn't another status. And Lord Carnworth expresses that dissatisfaction in the Stott case at paragraph 178. He's dissenting in that case, but for your Lordship's reference, that's page 1918 of the bundle. And really that is borne out by the exercise that Lady Black has to go through in her leading judgment in that case of reviewing all the authorities at length, coming to a position that was the case after Clift in the House of Lords, and then seeing how that's been modified, if at all, by the jurisprudence since. And the two key paragraphs, it may be worth turning them up, are the ones that the EAT relied on in this case at paragraphs 56 and 63. It's tab 61 of the authorities, which is bundle 3.
I don't think we put labels on the back of our authorities, but thank you. Is there anyone?
Oh, apologies. It's page 18. It starts at page 1865, and I'm going to page 1884. And this is where Lady Black sets out the position after the domestic decision in Clift and before the European Court's decision in Clift. At paragraph 63 on page 1887, she then goes through each of those Roman numbered points and says where they now seem to have ended up. To save your lordships the trouble of cross-referring, if I just go to paragraph 65 and tell your lordships what she says about each of them. She says 1 to 3.
Sorry, I got lost now.
Paragraph 56, my lord, has a series of numbered points.
Yeah.
And Lady Black's ultimate conclusion is that 1 to 3 still appear to be essentially good. 4 is questionable. That's the point that Ms. Krasnow addressed your lordships on. 5 is less helpful, but it may still be useful to have regard both to the list in the article itself and to statuses that have been identified in the jurisprudence and acknowledged. 6, she says, is not helpful in the abstract, and it will all depend on the circumstances. And 7, she says, is still good, but is a justification point, not a, is it a status point? And the cumbersome nature of that exercise bears out the difficulty of identifying any really clear or rational test or set of criteria for identifying what is and is not a status. We're left rather unsatisfactorily with only the first 3 bullet points being of much use and perhaps something like the common law process of proceeding by analogy as being an additional helpful way of proceeding. So the first 3 points, not unlimited, but to be given a generous interpretation, really just sets a fairly wide but not endless parameter. The second point, looking for a personal character by which persons or groups of persons are distinguishable, is to be applied, but personal characteristic doesn't in that context mean something that is innate. It may be a matter of personal choice, and the fact it is doesn't rule it out as a possible other status, but conversely what it doesn't say is that it's irrelevant that it's a matter of personal choice. Some matters of personal choice might obviously be so peripheral to anybody's status or identity to which Article 14 is ultimately directed. And doing the best I can to be helpful to your lordships on this by reference to this case, can I put the matter this way? That in this instance, being a foster carer is plainly a matter of choice. And so, although that's not determinative against it being a status, it puts it more towards the periphery. Not only is it a matter of choice, but it is something which, as was obvious from the material we went through, different people might end up making for a variety of different reasons, for a variety of different periods, which are not easily identifiable as a common status. And so where I submit one ends up is either being a foster carer, if one needs to add the additional characteristic of being a foster carer without a contract of employment, so be it, but whichever way it's put, either it is not another status, or it is certainly on the outer edges of the concentric circles to which the jurisprudence has referred. That's, I think, Lord Walker's phrase.
But religion and political opinion are at the heart of the...
Yes, things
Those
like...
are matters of choice.
Things like race and sex and sexual orientation.
Those are not choice.
No, they're not choice. And then religion and political opinion, and this is, I perfectly accept, choice is not a determinative factor.
But they're identified specifically in Article 14.
They are identified specifically, and they are identified specifically because what Article 14 is about at its heart is about characteristics which are important to one's identity.
That doesn't cover property.
It doesn't cover property, but the way it's engaged in respect of property is that Article 1 of the first protocol brings in property, and then Article 14, when you're looking at other status, is concerned with whether or not there is discrimination in respect of the right to enjoy freedom of possession of property, etc. So at the core of Article 14 are things that are either innate or are so important to one's identity that they're, in effect, equivalent to things that are innate. And then, as Lord Walker expresses it, there are a series of concentric circles which can't be limitless, and it's very difficult to draw where the limit is. And my submission to your lordships is either this is outside that limit, or it's on the outer edges of those concentric circles.
And if it's at the outer edges, the consequence you would say is that it makes justification easier.
Yes.
So you calibrate the severity of the burden by reference to how close you are to the core.
Yes. And Mr. Collins will develop the justification tests in due course, but that's the consequence of the analysis at this stage. My Lords, I ought to just briefly address Gillam, on which Ms. Krasnow placed some reliance in this context. It's at tab. Your Lordships don't have tabs. It's at page 2105 in bundle 3 still.
We do have tabs.
Oh, you do?
We do.
It's at tab 66. And Baroness Hale's reasoning on status is at paragraph 32. It may also be useful in this regard to see what she says on reading down at paragraphs 42 and 43. But starting at paragraph 32, as your lordships observed when Ms. Krasnow was addressing you, the reasoning is compressed. But the only point I'm going to, there's 2 points I think I need to address. The first is that the general point she seems to make is that occupational classification is clearly capable of being a status. And my response in relation to that is, see what I said yesterday about whether being a foster carer is really to be regarded as an employment relationship. That has essentially the same connotations as occupational classification, so the same points arise.
So you're saying that, this I'm sure makes it overcrude, but being a foster carer is not an occupation any more than being a parent would be an occupation.
Exactly.
So we have 3 different concepts: worker, employee, and occupation.
We do, but all amounting to roughly the same thing for these purposes, for applying a broad test in relation to the ECHR. The second point, as I understood Ms. Krasnow's submission, she was submitting to your lordships that not having a contract is what Baroness Hale held to be, being an office holder not under a contract, is what Baroness Hale held to be the relevant classification here, and that would be binding on your lordships in this case. In my submission, there's no finding in Gillam that is binding in respect of foster carers. Baroness Hale's reasoning slips between referring to the status as being a judicial office holder and something wider. So in paragraph 32, we have the phrases occupational classification in the first end of the first and beginning of the second line, non-contractual office holder in the third line, and in the penultimate line, constitutional position of a judge. So take your choice. And then...
Well, what's your choice?
Well, my choice is judge. You have a same inconsistency of language if one goes to what she says about reading down, beginning at paragraph 42.
Hang on 1 second.
What was question 3? He's answering yes.
The questions appear at the bottom of page 2115, between letters G and H. 4 well-known questions. 3 is it one of the listed grounds or some other status?
Sorry, you were taking us to 41?
I was taking your lordships to 42.
42.
The last line of page 2118, to interpret section 233b so as to include judicial office holders would not afford them all the rights afforded to workers. So there you have that phrase, but then at 43 you have the proposition it would not be difficult to include within limb B an individual who works or worked by virtue of an appointment to an office whereby the office holder undertakes to perform do or perform personally any work or services otherwise than for persons, etc. So again, moving from judicial office holder to something wider there. But the reason I say my choice is judge or judicial office holder is because that was the question before the Supreme Court. It's plain that in introducing the subject of reading down, Baroness Hale frames it by reference to whether it can be read so as to include judicial office holders. She expresses the wider view that it's possible to read it down to include office holders more generally, but she's not saying, and you should do that, because that would plainly be a question to be decided in the context of any other office holder of that kind. So what she says might answer the question as to whether it's possible to read down that definition in that case to include office holders, but she's not saying, and it is to be read down for the purposes of all office holders. The actual question she's answering is judicial office holders, and the status that she is addressing similarly in paragraph 32 must therefore be judicial office holders.
I had a difficulty, as you will have seen, when Krasnow was addressing us as to the exact structure of the reasoning in 32 line by line, or sentence by sentence. An occupational classification is clearly capable of being a status within Article 14. Well, that would obviously be judge. Clearly capable of being. That suggests it may be or may not be, but you get past the first hurdle. But it's not clear to me what the second hurdle is. Clearly capable of being, that you then need to say, and in this case it is.
Yes.
Where does she deal with that?
She doesn't, my lord. It may be, if I can put it this way, given that I think everyone agrees there isn't a clear and rational basis for making that decision, and given it seems to have appeared obvious to Baroness Hale and their lordships, maybe it is enough to say this obviously is.
Yes. But then the third sentence, indeed, it is the very classification of the judge. I didn't even understand. That reads like a sort of reinforcing point to the second sentence, because that's when you start something indeed, you mean, and this just shows. But I don't understand the reasoning. You can't help on that. Am I being dim? You're allowed to say yes, by the way.
I wouldn't dream of it, my lord, and the answer in any event is no. The reasoning is not spelt out very clearly. But as I say, that might simply be a function of the fact that this is not an area where there is an easily identifiable, coherent test to apply. And that may be a function of the observation I made at the start, that much as in, it's an analogous point rather than the same point, but much as in the domestic jurisprudence, as we know from cases like Shamoon, you don't have to separate out all of the strands of the test. You can take the compendious question, is this discrimination, by asking, is there a good reason for the difference? And if there is, that probably means the material circumstances aren't the same, so you don't have a good comparator. It's not quite the same point, but it bleeds into analogous situation and judge, because if there's a good reason for distinguishing, then then it may mean that it's not an analogous situation, and or it's not an identifiable status. Conversely, if there isn't, and then maybe that the status you're talking about is more identifiable because the distinction is not. But I'm not quite sure that works. But certainly the tendency of the European Court has been to move quite quickly beyond other status in an analogous situation and get to.
Can we be clear as to precisely what we say the characteristics of this? Use the word status advisedly, because that's not. The French language version seems to import a different concept. But you've just said we're dealing with a foster parent, foster carer. I think has the following characteristics: that they perform a duty imposed on a local authority under statute, so they're a non-contractual statutory delegatee. Therefore, that duty is legally owed and performed to the local authority, qua delegatee, but it's also, qua delegatee, owed to the child under Section 22 and 25 of the Children Act. So the status or the characteristics are of someone performing a statutory duty in two directions of, and one might add perhaps subjectively, of a very important social nature. Does it help to actually drill down a little bit, instead of just using that sort of sobriquet foster carer, to actually look at what that person's characteristics are?
Yeah, I think that does help to set out those characteristics and then to ask the questions indicated by the authorities. Is this a matter of choice? And the one that I've drawn out, how central is it to somebody's identity? And there was a third one, I think, implicit in what I submitted to your lordships, which is how common across the status that is sought to be relied on are the characteristics and the centrality of that status. And as I submitted to your lordships in this instance, it's a choice that might be made for a number of different reasons, for a number of different periods. Those are all things that make it difficult to identify as a common status across the status that is sought to be relied on. But
can I just tease something out here, which I think it's a non-point. I just want to see why it's a non-point. Classically, Article 14 claimants with statuses are individuals. And all your talk about personal identity is really only appropriate to an individual. The primary, well, really the only direct claimant whose rights are engaged here is the putative trade union, with the extra complication that in English law that's actually only quasi-corporate. But let's just suppose, ignore that complication, let us suppose that the trade union was a corporate body. How does Article 14 work there? We've been talking really about the status of the workers, not of the union.
yeah.
I mean, maybe this is just a very thoroughly technical approach and the two can, for all practical purposes, be run together. What's happening here is the union is saying my Article 14 rights are being interfered with, or sorry, I am someone who has Article 14 rights, I'm being treated differently from other corporate bodies. Does that make the Article 14 analysis more difficult, or do you just transfer all the Article 14 rights concerned to the members who are losing the benefit of being?
I think that, I mean, it slightly complicates it, but probably only theoretically.
Yeah.
I suppose there are 2 points. First of all, the rights of this union's members focus us back on I think it was 6 when the application was made. It's now 3. 3 people seem to have left the union. It focuses back on those actual members, and so we're then looking at their status, which, as Lordship and I observed yesterday, is not terribly satisfactory. So it may be appropriate to say the union's members and putative members is the status that we're examining. Not putative, potential members is the status we're examining. And what that may do is make the point I was groping for important, that if you're not just looking at an individual's characteristic, but you're seeking to identify a group status, then it of whether that group shares those characteristics to do with choice and identity in the same way, a more significant and relevant factor in the approach one adopts. My lords, I'm not sure there's a huge amount more I can say on status to assist your lordships. I haven't, I acknowledge, given your lordships a clear answer, other than to say whatever it is, it's either outside or at the peripheries, which is important for the arguments that Mr. Collins will develop. And obviously, if it's outside, then that's the end of Article 14. I equally can't give your lordships a huge amount more assistance on the next question of analogous situation, other than to say that it seems to me it probably depends on the points I made yesterday about whether the special protection for trade union rights under Article 11 are engaged, because logically, if they're not, then the reason that this organisation doesn't have the special protection for trade union rights under Article 11 is because it's not a trade union for ECHR purposes. And that must be a material distinction, which means the situation is not analogous for the purposes of Article 14 because it's a distinction that's inherent in Article 11 itself. Logically, conversely, unless there's some very obvious other distinguishing feature, it would seem to follow that if it is a trade union, it's in an analogous situation with other trade unions.
If it is a trade union, you mean if the members are Article 11 workers? If
the members are Article 11 workers, employees, because that's how you decide if it's a trade union, which is what engages those rights under Article 11.
Conceptually, how much further does Article 14 go beyond Article 11 if it's said that the justification advanced for the Article 11 interference is discriminatory?
It doesn't, because the test for justification under Article 14 is no more stringent. So ultimately, Article 14 is beside the point in this case. If
the claimant's right that it's a discriminatory justification, because it is the work of Article 14, sort of limb 4.
Yeah. My lords, unless I can help further on Article 14, the next question in the analysis is justification. Mr. Collins is going to develop that. If your lordships will indulge me, I've got 3 limited points I'll make, and I'll make them without taking your lordships to the authorities. The reason I make them because they lead back into some of the practical questions that I'm then going to come to in my concluding remarks on reading down and what the potential remedies or outcomes might be. The first of the three areas is just to summarise what seems to me to be the position on margin of appreciation and the manifestly without reasonable foundation test. The jurisprudence has gone through quite a lot of convolutions over the last number of years. And your lordships will probably find that the most useful cases, starting at the end and looking back rather than trying to plough through it from the start, are DA, the second benefit cap case at tab 65, Drexler at tab 72, and the Joint Council for the Welfare of Immigrants, another decision of this court, at tab 73. And I do this tentatively because of the convolutions I've referred to, but there seems to be some parting of the clouds to lead to this position. First of all, where the manifestly without reasonable foundation test applies, it applies to all aspects of the conventional four-stage test under Bank-Mallet. Secondly, manifestly without reasonable foundation test is not confined to welfare benefits cases. It applies more generally to general measures of social and economic strategy.
So not confined to
welfare benefits cases.
Yeah. But also to
cases which engage general measures of economic or social strategy. Thirdly, but it probably doesn't matter anyway, because even in a conventional proportionality assessment, the more sensitive the policy questions engaged, the greater the degree of deference that must be paid to the legislature and other branches of the state.
Hang on 1 second. What was your final, even in a conventional proportionality analysis?
The more sensitive the policy issues engaged, the greater degree of deference.
Yeah.
And lastly, it follows that whatever the test, if a sensitive policy area is engaged, especially in an area where the European Court would afford a wide margin of appreciation, considerable deference should be afforded.
Again, sorry, I was being slow. Whatever the test, in cases where
a sensitive policy area is engaged, and particularly where the European Court would afford a wide margin of appreciation, considerable deference should be afforded to the legislature and other state bodies.
So is that your first?
That's my first area. My second area is the submission that this is obviously a case that engages difficult policy areas, to use the phrase general measures of economic and social strategy. And it is so doubly, both in the trade union and employment regulation field and in the foster care field. That's made clear as a matter of authority in the trade union sphere. Domestically, and again, I'm not going to ask your lordships to turn this up, in the Boddington and Lawton case, tab 26, page 624 to 5, and at the level of the European Court in, amongst others, the Good Shepherd case, tab 93, paragraphs 159 to 172, and the United Kingdom, tab 96, paragraphs 60 and 66.
Yeah, and we summarised that in PDAU case.
Exactly. And Lord Hendy relies on passages in some of the other Strasbourg cases which say that it's a limited margin of appreciation, but the difference is where you are talking, all of those cases are cases which involve an absolute negation of an essential element of trade union rights under Article 11. So if a union cannot even exist or do anything, because unlike in this country, registration is a requirement for, and it's unlawful for it to exist if it's not registered, then a limited margin of appreciation applies. Similarly, as in the Demir case, if it simply can't enter into collective bargaining at all, then a limited margin applies. But the cases I've referred to are where there is something, it can do something within the relevant sphere, but it's there's a regulation of what and how much and in what circumstances.
Can I just ask you if this is part of your submission? When Strasbourg uses the concept of margin of appreciation, it is to justify different member states doing different things.
Yes.
So it says this is an area where it's appropriate for member state A, B and C to have different results.
Yes.
Once member state A, B or C has legislated, the margin of appreciation evaporates. It's really the conferral of the discretion on the state. Then don't you simply ask the related question, how big or how sensitive an issue is it? Is it political or is it more granular? And it's that which really determines the margin of discretion or judgment you then accord to the decision maker.
Yeah, I think that's
national level.
I think that's basically right. Mr. Collins may develop this in more detail, and I won't take up time doing it. But both sides, as it were, could take your lordships to dicta in the authorities, some of which say where the Strasbourg, something to the effect where the Strasbourg court confers a margin of appreciation, that should pretty much always be given to the legislature and the executive, and others that say not so. It's for the domestic organs of the state to decide between themselves who gets to exercise that margin of discretion, and in some cases the courts are the appropriate place to do it. The answer to that, I think, must be that whether it is constitutionally a matter that is properly within the scope of the court's responsibility, or it engages which are within the scope of the legislature. And that's why I started with the domestic position, making clear that regulation of trade unions and trade union rights, see Boddington and Lawton, is a sensitive political question in the UK, which, as a matter of general policy and constitutional propriety, should be for the legislature and the executive, not for the courts to decide upon. And the Strasbourg jurisprudence says something similar. It says these are difficult political and economic questions and social questions, and in characterising them in that way, it's not merely saying different states may do different things, it's noting that those are the sorts of things that the legislature should deal with.
I think it's probably correct to say that where the Strasbourg court accords a broad margin of appreciation, it is generally because it is an issue of high political sensitivity.
Yeah.
And that logic will then follow through into the national arena.
Yeah, that's right. And then in respect of foster care, as I said, it's doubly sensitive here. Could I, if your lordships will indulge me, I'm getting to my concluding remarks now, but I think this is important and leads me directly into the practical consequences. Could I just take your lordships to 3 references? Mr. Collins will develop the material on justification much more.
Sorry, just for my note, this is your third point.
This is the second part of my second point,
okay,
but it's leading into my third point. So This is to show your lordships that the policy questions engaged by the foster caring dimension to this case are equally difficult and sensitive ones. And in the second...
But just before we go on to that, are you saying that the difficult and sensitive question on which great deference should be paid to the view of the decision maker. It is whether workers not working under a contract should be included within the provisions of sections 1 and 296 of the 1992 Act, or the question of whether limits on the trade union rights of foster carers are in the best interests of children. I quite see what you say in relation to the second question, but if the first question is to be classified as a sensitive and difficult question of social and economic policy, then I would need some persuading, I have to say.
Well, it is both, but it's primarily the latter. And it's the reason I say doubly so, it's the combination of the fact we are in an area where conventionally regulation of trade unions is a sensitive political question, but doubly so given the foster caring dimension. I was about to take your lordships to the supplementary bundle, page 589.
These references you want us to go to?
If we could,
Yes,
my lords,
you
yes.
necessary, but-
This is within the Neri and Ower's report, which my lords will have seen reference. And they specifically consider the question of employment status beginning at the bottom of 589. Some foster carers and fostering organisations and trade unions are calling for foster carers to be regarded as workers or employees. And I just pause there to note, submission made to your lordships was that there's been no consideration to the position of trade union recognition. Well, it's right in the sense that nobody singles out that strand until we come to Ms. Willison's witness statement. But what plainly has been considered, both in the reports and by the government in its response, is the general question of employment or worker status, encompassing all that engages. And Mr. Collins will develop his arguments as he wishes, but as part of that, there is plainly something to be said for a bright line approach. Once you start saying, well, we're going to give you this particular status for some purposes and not others, then if the issue, as it plainly is from the materials, is about the encroachment of what seem like employment characteristics into what should be a caring parental role, affects the way that role is perceived by both foster carers and children, that's the concern, then there's something to be said for a bright line approach. And plainly what was in everyone's consciousness was that this is an area where trade unions are seeking to be active as part of that drive to make this more of an employment role. And that was plainly under consideration. And then over the page, you have some quotations which are given as illustrative, and then middle of the page, an acknowledgement that employment rights would indisputably bring some benefits to foster carers. So again, it's not right to say that none of the positive material has been considered. There is a recognition that there would be benefits from conferring employment rights, but then let's go on to say that their judgment is that would have deleterious effects which outweigh the potential benefits. I won't take your lordships to the government's response. I'm sure Mr. Collins will, but for your lordships' reference, it's at 512 to 513 of this bundle. But what I will do finally on this point, if I may, is go back to ECRU's skeleton argument, which is in the core bundle, and I'm not sure my page references for the core bundle are right. The page I would like to go, or the paragraph I would like to go to is paragraph 30 of ECRU's skeleton argument, which for me is page 254.
I just be clear? If you're saying no more than the question of margin of appreciation as it applies to children is a sensitive, difficult area, I don't think I have much difficulty in accepting that. If you're trying to persuade us that there was sufficient evidence in front of the tribunal based upon the references that were before the tribunal that was an adequate evidential justification, that's a quite separate issue, isn't it?
It is, and I'm not in fact doing either. I'll leave it to Mr. Collins to persuade you that the material is sufficient to meet the test for justification. I'm, as it were, now about to develop a point beyond that. If it's not sufficient, where do we end up? And the reason I go to paragraph 30 is because Mr. Burton says there, and he frankly acknowledged the same position in his very helpful and clear submissions to your lordships yesterday. Second line, the implications of foster carers obtaining worker status or foster carer unions being listed were multifaceted and offered potential advantages as well as the disadvantages for foster children highlighted by Ms. Willison. And he makes a similar point at paragraph 37B, it's page 12 of the internal, paragraph 32, a couple of pages on. It is recognised that the position he had developed did not necessarily mean the AT was bound to find the interference with Article 11 was disproportionate. Skip a bit, and then it remained open in principle to the AT to accept that the decision was justified by reference to the interests of children by carrying out its own compliant assessment. However, in practice, this would be extremely difficult, if not impossible, without a compliant decision to which it might defer, and in the absence of the evidence necessary to make its own determination of best interests. So, if I'm moving beyond Mr. Collins's submissions, which are to follow, if Mr. Collins fails to persuade you on justification, then at the very least, the position we end up in is that there is evidence pointing in both directions, and it is positively submitted by the intervener with the greatest knowledge of the material in this area, that the evidence that is before you, for the AT, is not sufficient to make a good assessment. And that this leads into my third and final observation in this area, which is, what is the consequence of that? And one of the, Mr. Burton, to be fair to him, was fairly tentative in his submission on this, but one of the consequences that he submitted was that because the burden of proof is on the Secretary of State, if the Secretary of State fails to prove justification, then your lordships should find that there is a breach, and hence that there should be a recognition of the status of foster carers in the Union for some purposes, whatever they may be in this case. And I just start with the observation, not really grounded in any particular authority or dictum, that it would be extremely unsatisfactory to decide that what has hitherto been the status of foster carers and what the Secretary of State says should be the status of foster carers should not be on a burden of proof point.
I think your point, if I can put it slightly differently, if the conclusion is that the evidence base was inadequate, then the tribunal, as a public authority under the Act, would not have been in a position to conduct a proper assessment and therefore couldn't come to a conclusion. And it wouldn't be right to say that because they found the respondent's evidence not good enough, therefore you can positively conclude there is emphatically a breach. The tribunal should then say, take the mid-course, which is, if you like, not proven, but we can't necessarily come to a definitive view of our own in the absence of proper evidence. Someone's got to do a proper evidence assessment.
Yes, that would be one route through, although where that leads to, and coming on to reading down and possible outcomes in a moment, but where that leads to is a difficult question. Can I offer one alternative route through that position, which, again, I preface by saying this is difficult. I'm not sure this is a satisfactory answer. But in the DA case, at tab 65, your Lordships may wish to turn this up, but may not. I can make my point, and Lordships...
Make the point first, then we'll have a look.
At paragraph 50 in the judgment of Lord Wilson, which I think had enough agreement to make it part of it was the leading speech in that case. Paragraph 50, Lord Wilson makes the unobjectionable observation that the burden is on the Secretary of State to prove justification. Then, having gone through the manifestly without reasonable foundation test, which he held applied in that case, so if that test applies for us, at paragraph 66, he says, so how does that work in the context of the burden of proof being on the Secretary of State? And he doesn't quite say it in these terms. He doesn't say the burden is reversed, but he does say, in practice, the consequence means that if the Secretary of State puts enough before you to show it's being considered and isn't manifestly without reasonable justification, then it flips back to the other party to seek to persuade you that it's not. And
your proposition here is that the hypothesis that we might proceed upon is that the Secretary of State didn't put sufficient information, so you have an evidential void.
Yes.
I see that. I mean, I think the switching burden has been addressed in a number of cases. It makes sense. If there's a prima facie case, then that case wins unless the other side comes back and debunks it.
Yes.
But if the conclusion of the tribunal should have been that there just wasn't enough evidence for it to form a view, it's then left in this halfway house.
Yeah, no, I follow your Lordship. I think that must be right. So the point I've just made, in fact, comes first. Applying the manifestly without reasonable foundation test, it's not quite right to say there is a strong burden on the Secretary of State as the Secretary of State puts up that prima facie case and it's then for the other party to knock it down. And my Lord, that's a similar point to the reconciliation that your Lordship explored between the two paragraphs in the EAT's judgment in this case, where it says it's not in a position to find that that what's best for children, but the Secretary of State has done enough to meet the test upon it. Maybe that's how you reconcile that within the scheme. But then, if your Lordships don't find that the Secretary of State has even done enough to meet that threshold, then I think my Lord is right. The position you reach is that there is an evidential void. As a public authority, this court can't, no more than the EAT could, decide what is in the best interest of children. And then we come to my final area, which is where do we end up in this case and what are the options available to your Lordships? Essentially, three potential outcomes have been explored, I think. The first is that your Lordships find that there has been a breach, there isn't an evidential void. We don't end up in the evidential void position. You find there is an unjustified breach, which you can positively say is not justified. And then the question becomes, can you read down Section 2 to some extent, if at all? And I think, my Lords, we've explored the issues in relation to that sufficiently. My answer is the definitions are fundamental and therefore applying the well-known test, you can't read down. And if I can put in this plea on behalf of the certification officer whom I represent, one of the things she is obviously anxious about is that in this case there is somehow a green light given to any putative trade union to apply for listing under Section 2 in the way this is done as a vehicle for trying to explore the whole suite of rights. And that is not the function of Section 2 as I submitted to your Lordship. Now, that's not to say that as a public authority, the CEO doesn't have a duty to apply human rights under the 1998 Act if they are properly engaged. But what she would not feel competent, either personally, or more importantly, constitutionally to do, is to engage in that exercise that we've done at great length before your lordships, of trying to review and say, well, I can't list you under section 2 as it stands because I can't say you meet the definitions, but you ought to have some of the consequences of section 2, and I should now try to decide which of those consequences should follow. That would put her in a very difficult position, and I would invite your lordships to make clear that that would not be her role in any future application, precisely because of the difficult policy questions that would engage. It would all... My lord has a question for me.
I'm just thinking, it obviously could happen, but a lot of those issues might have to be explored otherwise by trade unions which already exist. If you're talking about compulsory recognition in the case of foster carers, in which case you need to decide whether or not they were workers. We're told that the IWGB already has a foster carers section. That's part of the reason why Lord Henley is here, or the reason why he's here. They're an existing union. There may be other unions which wants to recruit foster carers, or does recruit foster carers. It's unusual that your client has been put in this position because it is a new union. I'm just wondering how serious, whether this situation is likely to occur very often.
It may be that it won't, and who knows? There are some creative, putative trade unions out there, and they have some excellent strategic legal advice. But
they have to be unions wanting to represent non-workers.
Yes.
I see. So I suppose that could be the case with a whole lot of gig economy.
Depending on where...
happens in Uber.
Yes.
Yeah, okay. I'm just seeing whether... I was trying to work out how real a concern this is, but I see it could be. Yeah.
My lord, the second... and this is really a substrand of the first, but the second possibility that was ventilated, I'm not sure how seriously, was sending this back to the CO to get more evidence and make a decision on the basis of additional evidence. And my lords asked us to clarify what the CO's powers and procedures were. I'm hoping at some point today an email will arrive for your lordships with 4 things attached, perhaps as a single attachment. One will be section 256 of the 1992 Act, which is entitled Procedure Before the Conciliation Officer, and simply says, so far as material, that except in relation to matters as to which express provision is made by or under an enactment, the certification officer may regulate the procedure to be followed, amongst other things, on any application made to him. So it gives us a broad discretion to regulate the procedure, but doesn't confer a particular power to call for evidence from anyone other than the person making the application. And that is borne out by the second thing that will be in the material we provide to your lordship, which is Schedule A3 to the Act, which is entitled Certification Officer Investigatory Powers. I won't read out all the provisions of that schedule to your lordships, but that does give the certification officer powers to call for information and documents, but only in respect of trade unions, and so wouldn't give the certification officer power to call for other material from other sources. Penultimately, we will provide the guidance that is on the certification officer website as to the procedure. So the certification officer hasn't, in the exercise of that power under section 256, made formal rules. It simply says on its website, for the purposes of a section 2 application, something to the effect, we will investigate by asking for information either in correspondence or face-to-face. And so the practice is that there's correspondence, as there was in this case, and if necessary, a meeting is held. It's not called a hearing, in order for the certification officer to ask questions and get the information she needs to make the decision. And then the last thing we will give to your lordships, just because we thought it would be helpful for your lordships to have in mind practically what it is we've been arguing about, is that the first page of the online version of the list, which sets out some preliminaries about the purpose of the list in accordance with the statute, and then has the schedule with various columns. And what your lordships will see is that there would be a practical difficulty there. Sure, it's not insurmountable, but there would be a practical difficulty if we were to be listing for purposes other than all of the purposes under the statute, i.e. that this is a trade union within the definitions. It would require some new way of annotating and explaining the entry on the list. I understand that material was sent about half an hour ago, so your clerks should have it, my lords, and be able to print it out. So, so that in my submission makes good my first point that it's really not something that can properly be done under Section 2, certainly not by the certification officer, and the second point that she would certainly be horrified at the thought of having to decide these issues on it being sent back, but more importantly, the process and the powers simply don't make it an appropriate forum within which to address those questions. And then the final practical option that has been canvassed is a certificate of incompatibility, and
or remit to the tribunal.
Yes, I was wondering that.
or remit to the EAT.
Remit to the EAT.
Oh, that's
To carry out a proper fact finding. And I was just thinking, as you were talking, I was wondering what would happen if at the end of a hearing in front of the EAT, the panel came to the view that they were suspicious about justification, that they felt uneasy about the level of evidence. They could, in a judgment, say, we haven't found ourselves able to come to a conclusion. We're therefore going to adjourn, go further back into case management, and now require a proper set of evidence and be put in, and we'll then move to a judgment. If it's remitted to the EAT, they can simply issue directions requiring people to attend for a full investigation.
Have to look at
Yeah.
speaking as a former president.
Yeah. I'm talking off the top of my head.
Yes, no. I mean, I was thinking the same thing. It would be surprising if it didn't have such rights, if it were such powers, if it were necessary in order to fulfil its duties under Section 6. But I'm pretty sure they're not expressly provided for anywhere, because it's normally an appellate tribunal. And this would still be an appellate role. But what we're used to, I think my lord is reminding me, I forget whether in court or out, appellate tribunals do in human rights matters quite often entertain evidence, less often oral evidence, but do entertain fresh evidence in order to decide proportionality matters. The Supreme Court are very willing to hear new stuff.
We were talking about as unison.
Well, unison was a bit of a strange case because the evidence was actually developing as the appeal went on, so it was genuinely new evidence. This wouldn't be new evidence in the sense it couldn't have been available the first time round. But that makes it, by a conventional analysis, more difficult to say why it should be heard by an appellate body. But, again, until I'm thinking aloud, the EAT is effectively the first body set up as a court that has the power to make, that is well set up to make this analysis, if it's required. I mean, maybe it's not required, but we're just seeing how it could be done if it were.
yes, my lord. I'm just.
You won't find anything relevant in the EAT rule.
I started in the EAT in the Employment Tribunals Act 1996 at section 32C does provide the power for rules to cover requiring persons to attend and give evidence and produce documents. And then I was
It does actually have, EAT does have a very limited, I've actually forgotten what it was never called on in my time, has a very limited first instance jurisdiction.
Yes.
As we've been looking at, in a way, appeals to the certification officer are a very odd sort of an appeal, because they're not an appeal from a tribunal. They're they're not judicial review either, but they're more like a judicial review.
And then Rule 27, entitled Attendance of Witnesses and Production of Documents, provides that the appeal tribunal may, on the application of any party, order any person to attend before the tribunal as a witness or to produce any document.
Well, I think rather than decide all this on the hoof, we may never get there. I think it would be helpful, since we didn't have plenty of emails already, if we had a short email drawing our attention to any relevant powers or any relevant problems about the powers of the EAT to conduct this assessment, either under its statute or under its current rules. But certainly if it's under its current rules, and probably even if it's under the statute, it would have to be if it was the right thing to do for Human Rights Act purposes, I'd be surprised if Section 6 wouldn't give the authority.
My Lords, that's been, I think, very helpful.
Anyway, you were about to tell us that your third option, which was declaration.
Which was declaration of independence.
You've been saying certificate. It is
declaration. I'd written COI on my notes and
don't worry, no. I just wonder whether I've been getting it wrong all these years. It's formally a declaration of incompatibility. Yeah.
It is declaration of incompatibility, which would have the potential consequence of prompting the Secretary of State to think again, but has the problem that you then have to try and define precisely the scope of the incompatibility, which is
the conceptual problem
which is the
tribunal's come to the conclusion it doesn't know.
Yes.
It would be odd to then say it can issue a declaration of
yes.
incompatibility, and one feels slightly uncomfortable with interfering with something that Parliament has done in, ordering a procedure which engages Parliament when you don't know whether or not they've acted improperly or not.
Yes. So I'm certainly not actively promoting that, but it was in there amongst the provisions. My Lords, if you'll forgive me turning my back, I'll just check whether there's anything that I haven't said that I need to. Oh yes, your Lordships had a question about the significance of any of sufficient evidence in Scotland. Yes. The short answer is it's what we thought.
Two ways of saying the same thing.
Yeah. My Lords, unless I can assist further, I've taken up an awful lot of your Lordship's time.
No, all of it's been helpful, as with all the submissions we've had so far. I'm sorry if Mr. Collins feels he's been shut out, but the more we hear, the more focused our submissions, our questions to him will be. So.
It's implicit the email we referred to earlier would benefit if it were an agreed email.
We will try and agree it. Thank you.
Yes, Mr. Collins. Now, do you want to come forward?
That'd be great if I can
No, we'd prefer that.
finally get to the front.
No. Too late.
Thank you. It's just that I've got a laptop with the authority on it.
Don't worry at all.
And my eyesight has got to the point where I won't be able to see it if it's all the way down on the desk. So it's not an attempt to appear grand or anything like that. My lords, I'm grateful for your patience while I've got myself set up there.
No, of course, that's fine.
My lords, in broad terms, the Secretary of State agrees with and endorses the submissions that my friend Mr. Cooper has been making this morning and yesterday afternoon. There are one or two points where we will differ, perhaps, in the emphasis which we place on certain issues, but I'll as I go along. I propose to address the court primarily on the question of justification for the purposes both of Article 11 and Article 14, but I want to add just a little to what Mr. Cooper said, firstly on employment relationship and secondly on other status for the purposes of Article 14.
Yes.
My lords, before I get into the meat of the argument, there's one preliminary observation which I wish to make, and I take it from one of the documents that we have in the supplementary bundle at page 473. It's from the House of Commons Education Committee report, and seemed to me right to preface my submissions by saying this.
Hang on 1 second, sorry.
My lord, yes. Supplementary bundle, page 473.
Yes. It says intentionally blank in ours.
473 itself isn't blank. 474 is blank. Oh.
473 conclusion.
Yes, just the conclusion. So what this is from, let me just write this down, so it's probably in the index, but it doesn't say on the face of it.
I'm going to take my lords through all of the evidential materials in just a moment, but it's from the House of Commons Education Committee report.
Yeah.
This is by way of introductory comment only. And it says this: foster care provides an invaluable service to society. It gives homes, love and care to some of the most vulnerable young people, allowing them to recover from often traumatic experiences and grow up in a family environment. It's an immensely challenging role, which is performed with dedication, love and often great sacrifice by foster carers, both to themselves and their families. We place on record our appreciation to the thousands of foster carers who open their hearts and homes to caring for our young people, and to all involved in the wider foster care system who work on a daily basis to improve the lives of children across the country. My lords, it seemed to me that it wouldn't be right for me to make submissions on this appeal on behalf of the Secretary of State without emphasising that message at the outset. And having done that, I turn to the substance. And to do that, I need to take you to the evidence. And there are, my lord, several hundred pages of reports to which, notwithstanding that your lordships have heard 11 or more hours of submissions, have been barely touched upon. And it's important in our submission that you understand the nature of the material which is available and where it's come from and when. And I propose to take the court to them chronologically, if I may. The first, they're all
material which was before the EAT.
Yes, it is.
But it's not referred to in the EAT judgment.
Whether there are references to all of this in the EAT judgment, I'd need to double check. These were appendices to the witness statement of Ms. Willison.
And the only point I'm making is that we're obviously reviewing the EAT's judgment.
Yes.
Not necessarily forming an opinion of our own about the evidence.
That's absolutely right, and it's an important point. But what you'll need to in order to do that is to understand what materials before the EAT. One of the propositions that you've heard is that there was insufficient evidence to satisfy the EAT, that the Secretary of State had done his job properly, or perhaps more correctly for the purposes of this appeal, the certification officer had done her job properly. And we say that, as I take your lordships through it, we'll say that that's plainly wrong, that there was a wealth of material. But it's important for your lordships, when we come to look at questions of proportionality in particular, but also when we look at the exercise which the EAT was required to perform, it's important to understand what material was was available. And the first report chronologically is in supplementary bundle page 28. It's been referred to as the Baginski report, entitled The Fostering System in England Evidence Review. It's a research report conducted for the Department of Education, and it's an enormously detailed document. I don't propose to go through much of this at all at this stage, but one can see just from the contents pages, which start on page 29 and go on for several pages, that there's an awful lot of evidence which was reviewed by the authors of this report. And can I just flag up, for example, we see from page 99.
That's 99 in our bundle.
I hope so.
Yes,
It's not in my bundle. It's in the middle of the page.
I wasn't
heading.
making that kind of point. I was simply wondering whether you were referring to the internal page.
No, I'll confine myself to bundle pagination.
Yes, of course.
To try and avoid confusion. One can see there's a section on the recruitment of foster carers, and there is some analysis. We don't have all of it because some of the pages have been omitted, but one can see over the page at 100 recruitment strategies. 109 and 110, a debate on the status and professionalisation of foster carers, questions about retaining foster carers. And in that context, page 113, questions of financial reward are considered. And we go right through to, I think,
1 second,
I'm
sorry,
so sorry. 113 is a section on financial reward. And this question of retention is considered right through to page 117. And I flag that up because it appeared to be suggested at one point by Mr. Burton that those questions had not been considered by the Secretary of State in the material before him. And we say that's plainly wrong.
So this suggests there is a link between pay and retention.
There is evidence which suggests that there is, in some cases, a link, in others less so. But yes, more of a link with retention than with recruitment is one of the conclusions that this report reaches. So that report is from April 2017. And one can see the way in which it came to be written from page 35. I'll go back to the beginning of the report. My lords can see there's a section headed Background to the Review, which notes that in the summer of 2016 the government announced a national stocktake of fostering in England to reach a better understanding of the current system and where improvements can be made. And this review, the Baginski review, was commissioned to inform the stocktake, intended to bring together quantitative and qualitative research to contribute to an overview of the fostering system, providing a brief description of the fostering system, how it operates, and the impact of foster care on the children placed with foster carers. I'll come on later in my submission to deal with the best interests question, but at risk of stating the obvious, all of this material is focused on only one thing, the best interests of children. Of course, there are sub-issues about how to recruit and retain foster carers and all sorts of points of detail, but what's it all for? The purpose of the system, plainly, is entirely focused on the welfare of the children. And my lord, that's the first document. As I say, when I come to the meat of the justification argument, I'll look at some of the content of these documents, but this is just to set the scene. The next document that we have chronologically is at page 424 in the supplemental bundle. And that's the report of the House of Commons Education Committee on fostering. That is from December 2017. And I'll take your lordship to the content of that in due course. Chronologically, next we then come to what's been described as NARI. That's page 544. And that review by Sir Martin Nary and Mark Owers was a review for the Department of Education undertaken in February 2018. And there's a description of the, in the acknowledgement section at the outset, 548, where Sir Martin Nary says, "We hope this review offers a thorough critique of foster care in England with realistic and affordable recommendations." And it says in the next paragraph, "We've not investigated every fostering related issue, but we have probed every issue which we were urged to review by carers, professionals, or children and young people."
So sorry, where are you reading from? This is from page
548, my lord.
548, yes, thank you.
The second paragraph.
Does it make clear somewhere what its relationship is to Baginski? I see Baginski is referred
yes,
to.
just by the lower hole punch. It's drawn from Baginski for its conclusions, if I can put it that way. So Sir
Yes,
Martin says,
I expressed myself badly. What I really meant was why the government wanted it, what different job it was supposed to do compared with the Baginski job.
the Baginski report was a review of the evidence.
Yeah.
So that collates, if you like, a wealth of materials
Yeah.
so as to inform the Secretary of State.
It didn't make recommendations.
That's not its task. It perhaps makes observations in its course, inevitably perhaps, given its nature. Whereas the Nary report is more focused on making recommendations, describes itself as a thorough critique of foster care.
Yes. Was Baginski done for the purpose of Nary?
I'll check. I don't believe it was.
It probably doesn't matter,
check.
but I just want to get in my head. The Department of Education commissions these two. That it must have had some coherent strategy for what it was doing, and I was wondering how these two fitted into it.
Well, can I double check that over lunch? The other material that feeds into this report are the views of the Children's Commissioner. One can see right at the bottom of page 548, 2 lines from the bottom, the Children's Commissioner independently surveyed the views of children for us and has been encouraging throughout. Mr. Burton, yesterday I thought I heard say that there weren't any surveys in response to a question from the bench. That submission was plainly wrong. In fact, I'll take the court to a survey by Ofsted at one point in due course as well. And the survey itself by the Children's Commissioner appears at 649. One can see there an introduction and a number of findings, and the description of what took place is at 650. Children's Commissioners gather the views and experiences of children in foster care to inform the National Fostering Stocktake being conducted by the Department of Education. And again, I'll take the court to some of the detail of this in due course, but just turning over the page so you get a flavour of what's contained in there. One can see quotes, descriptions, some pictures and so on and so forth. So that's February 2018. The next material, which was before the EAT, is at 484. And this is the government response. 484, Fostering Better Outcomes is the name of the document. It's the government response to the Education Select Committee report into fostering, which we looked at, and foster care in England. That's the title of the NARI report. So this is the government's response to the Select Committee report and to NARI.
Sorry, Mr. Collins, which page?
484, my lord.
Thank you.
And that's dated July 2018. Now, the only other document that my lords have in the bundle which contains evidence of this sort, we've been referred to the Fostering Network report at page 729. That's dated February 2019, so that came out after the Secretary of State had set out his position to the EAT.
Was that February 2019?
Yes.
That's not a commissioned document at all. That's something Fostering Network has done for itself.
Precisely, yes. Fostering Network being
And the Fostering Network, we were told, is effectively a network of there are local networks, have I got this right, of local associations with a small a of foster carers,
Well,
and they have a national umbrella organisation, which is the Fostering Network. Is that wrong or right?
my lord, that's roughly right. So the Fostering Network, it's a charity, which it partly derives its existence from its members. So it has membership fees, but it's also funded by the government for projects. There's a description of it in the supplementary witness statement of Katie Willison, supplementary bundle, page 669. The court perhaps doesn't need to turn it up now, but just for your note.
Yep.
But it's one of those organisations which campaigns on behalf of foster carers to bring about improvements for members in terms of policy. Of course, it's not the only one of those organisations.
I think I know the answer to this, but it is specifically represents foster carers themselves, local authorities and or fostering agencies are not members. Is that right?
I'd need to double check that, my lord. I think that's certainly my impression of it, is that it represents the individuals rather than the commissioning organisations, if I can put it that way.
Yeah.
If I can say.
Well, we will assume that unless we're told to the contrary. That was the
Precisely,
impression I got.
if I've got that wrong,
check.
I'll correct myself after lunch.
Yeah.
Well, just to conclude my introductory tour of the materials, can I just say something about the chronology as well of these proceedings? Because questions have arisen about what might have been done when. I won't deal with that at the outset, but if I can just give the court a rough chronology at the outset. The court's seen that the certification officer's decision was taken in July 2017, and the appeal was launched in November 2017. There was then a hearing in November of 2018, by which time, as we understand it, the IWGB had expressed an interest in intervening. And as we understand it, somebody at that hearing queried whether the Local Government Association and the Secretary of State had been given the opportunity to intervene. Although, in fact, at that stage, as I understand it, it was thought that the relevant Secretary of State would be the Secretary of State for Business, Energy and Industrial Strategy.
Yes.
And the then President of the EAT gave some directions.
So was this a hearing was this a case management hearing, or was this an abortive full hearing when it was realised that not everyone who ought to be there was there?
I'm not the best person to answer that.
Yes.
It was
It was which?
a case management hearing.
Right, thank you.
And the general chat about who might usefully be present. And I believe that it was the CO who indicated that government should have a say, not just be represented by the CO himself. And then there's correspondence that, my lord, we've forwarded to...
Yes, but I think Mr. Collins will probably be coming to that.
Of course, yes.
Yes.
Yeah, it
Yes.
wasn't the final hearing.
No, I just wondered whether, I mean, obviously it wasn't the final hearing, I wonder whether it was intended to be the final hearing.
I think it was thought there needed to be case management.
Yes, okay, thank you.
I'm very grateful for that. And it's absolutely right. The certification officer then notified the Secretary of State, or a Secretary of State at least, and the Secretary of State put in a request then in December of 2018 to intervene.
And that was your Secretary of State?
Yes, it was. I think that's what was emailed to the court by my learned friends overnight.
Yeah. Yes, we saw that. We only saw it this morning, and just before we came into court, so I didn't read it. It's quite long.
It's along the lines of a letter of claim or letter of response type
Yes, that's-
document in that it sets out the
Well,
position.
we won't read the detail unless we're encouraged to.
I
Sort of, we might read it. Will you want us to read the detail, or is it just part of the story, Miss?
It's
Sorry,
largely part of the story, but the significant point is at that stage, the best interests of the child issue was set out in some detail.
Very well. We will read it over the adjournment. Thank you.
no dispute about that. As I say, it was along the lines of a letter of response setting out the Secretary of State's position. A formal response was then put in January.
Just out of curiosity, unless you're coming back to it, I see obviously why the Secretary of State for Education is interested, or rather for children, but you might have thought BES is pretty interested as well. But you are definitely only a decision was made that you would be instructed only on behalf of the Secretary of State for Education.
My lord, I am only instructed on behalf of the Secretary of
You're
State
therefore,
for Education.
presumably, it must follow, not in a position to tell us why the Secretary of State for Business, etc., didn't feel it was necessary to intervene. Or...
I'm not in a position to deal with that. One of the things that I may be saying right at the end of my submissions is that if you're minded to think about a declaration of incompatibility, that's a point at which the Secretary of State for BES, I'll get it wrong if I use the individual words, may need to have something to say on the matter, because that's not a matter which has been canvassed as part of this appeal before. And I don't speak on behalf of the Secretary of State for Business.
Well,
Energy.
let's not get bogged down by that, but that's actually quite a big question, isn't it? On the face of it, the government is a necessary party when we're going to make a declaration of independence, a declaration of incompatibility.
Yes.
You represent the government. That's true. You represent a different Secretary of State. I can't remember what the statute says, but I doubt if it makes a distinction between different Secretaries of State.
It's right to say that constitutionally there is a position which is of the Secretary of State.
Right, exactly.
There's no constitutional difference between the individuals.
Well, I'm just wondering whether it's entirely appropriate to say that the Secretary of State. I don't want to get bogged down in it, but I ought to flag it up. For you to say, oh, well, there may be a problem because the Secretary of State isn't here, or the right Secretary of State isn't here. You are here.
Yes.
And if the government wants to make submissions, they ought to come through you. And if you haven't got the relevant instructions, of course, we'll have to decide how to handle that. It may be something we have to deal with if we get there. But don't...
My lord, it may be a better way to put it to say they ought to be given the opportunity to give me instructions on that issue. But
well, we may well take the view, even if we get there, that's essentially something on which we will have to have at least further written submissions, possibly even a short hearing. But let's...
My Lord anticipates a submission I'll be making at some point this afternoon along those very lines, but I'm getting ahead of myself.
Yes, thank you. It's worth flagging up now. Yep, thank you.
My Lord, can I just interrupt very briefly to add to that missing bit of the jigsaw, in that the Bays did write to the EAT in December 2018, saying, grateful to be informed of the litigation and the issue to be determined, Secretary of State's decided not to intervene at this stage of the litigation, aware Department of Education has sought to intervene.
Yes, I see. Well, that's
We'll
very
keep our
helpful.
position under
But for
review.
completeness, could we be sent that by whoever has it, just to tell the story? Of course, part of the complication is that the EAT wouldn't have had power to grant a declaration of incompatibility. At least I'm 90% sure that's so. We checked that ourselves. I forget we said that yesterday.
My Lord, I think that's right. And then we'd come before this court, and I think it's right. So the first that I was aware of declaration of incompatibility being canvassed as an option for this court was a suggestion from Mr. Cooper yesterday afternoon.
Oh, well, I mean,
I may have missed something, my Lord, but
I'd always assumed it was in there as a possible outcome, but whether I got it with the skeleton arguments or just assumed it, I don't know. Anyway, there we are. Let you keep going with substance.
well, I was just completing the chronology of how we got to where we were. Skeletons were exchanged in the EAT in March of 2019, and the hearing itself took place starting on, I think, over 4 days, starting on the 28th of March.
Just going back, completeness, the fostering network report was before the EAT. It predates it.
It predates it. It wasn't appended to Ms. Willison's witness statement, so it may not have been.
Right.
That I will have to double check. I'm sorry, my Lord, I don't know.
I'm sorry, because we were too busy I was too busy talking. What did you say happened in January 2019?
January 2019 was when the Secretary of State put in its pleading, in inverted commas,
Okay,
for the EAT, its intervention.
thank you.
Broadly reflected what it said in the correspondence of December. I just wanted the court to have that chronology available. We may
Yes.
need to dip into it when I come back to submissions on, in particular, the best interest of the child in due course. And, my Lord, having done that, then I go on to deal with the substantive issues. First of all, on employment status, I've got just a very little to add to
Yes.
what Mr. Cooper said yesterday. And of course, it's important because if we don't have employment status, then we will say that Article 11 doesn't apply to these circumstances at all. I'm sure my lords have the point, but just to spell it out, Article 11 provides a right of freedom association. And of course, there's no question here but that members of the NUPFC are free to associate. There's a further right to form and belong to a trade union, which arises, but not every association is a trade union. And as we saw yesterday from the Good Shepherd case, the right to form a trade union is applicable where the circumstances amount to an employment relationship. That's paragraph 141 of the Good Shepherd. The Strasbourg jurisprudence tells us that the crucial hallmarks of an employment relationship, which essentially are derived largely from ILO number 198, are the performance of work and the remuneration of the worker. Paragraph 142 of the Good Shepherd. And of course it's a multifactorial analysis, but that's what in domestic employment law we would call the irreducible minimum. Again, to give it a domestic label, the wage work bargain. And that's why the question of remuneration is important. And we submitted before the EAT that it was important, because if you don't have it, then we're not in employment relationship territory. and we are not in Article 11 territory, save for freedom of association, which nobody has an issue with in this case. And the difficulty with this case is that there is no evidence that any member of the NUPFC received any remuneration or any work. The only evidence before the EAT was the foster carer partnership agreement. I think your lordships were taken to it yesterday, but it may be helpful to have it in front of you. It's in the supplementary bundle at page 691. And this was essentially all the EAT had by way of evidence about arrangements for payment. Mr. Findlay's statement didn't add anything to this. The agreement starts at page 691. The only parts of it which deal with finance are on page 692. Near the middle of the page, there's a heading Finance Support. There's a reference there to financial support being provided by the Directorate through the foster care allowance. And that's the allowance paid to cover costs rather than a fee for labour, if I can put it that way. And then there's a reference at E to retainer fees, which are fees paid not for taking care of a foster child, but for holding a vacancy, so being on standby, as it were. And the EAT concluded that there was no material there which would enable it to find a wage-work bargain. It said the evidence was inadequate. Fair to say it didn't go on to say positively no wage-work bargain. It said we can't make a finding in the circumstances. We don't have enough material.
Did it say that because this was only the Haringey version and there was evidence certainly that foster agencies and I think also some local authorities pay a fee as well?
No, it didn't say it for that. Perhaps I should take your lordships to the judgment. It's paragraph 65 of the EAT's judgment. It's my page 96 in the core bundle. But having sat here for 2 days, I fear the pagination may not be identical in your lordship's bundles. It's somewhere near page 96, and it's paragraph 65 of the judgment. The court has my submission.
Yeah.
One can see there, Mr. Collins submits the agreement between foster carers and the local authority does not involve the provision of work in return for periodic remuneration. Refer us to Mr. Findlay's FCA. That's the passage I've just taken the court to. Nothing further is said about allowances or fees in the agreement. It's clear the allowances payable are intended to cover the costs of providing foster care. The retainer serves the limited function of providing some compensation. There's nothing in this agreement which represents any remuneration for the foster carer in return for providing the work of looking after a child. Those are findings of fact, and we say they're findings of fact the EAT was well entitled to make.
Yes, Mr. Collins, but they're findings of fact about this particular agreement. And
Yes.
then they go on, if they'd said at the end of paragraph 66, and that's the end of the case, goodbye, that this point would be very important, but surely we have to look at paragraph 70.
Well, my lord, yes, and I hope I said they didn't go on to say that was the end of it. I did make that clear, and that's why I'm taking you through. They said, in the end, that no clear conclusions could be reached. And, in fact, I'm reassured that I did say that to the court, because my Lord Justice Underhill has just asked me why they found that. Was it because of other types of agreement? And the answer to that is
Yes.
well, it's
Isn't that what 70 is saying? In our judgment, no clear can be reached in positions it applies generally to foster care.
Yes.
And that's on the back of Mr. Hendy having referred to
Yes.
evidence that there's often a fee paid.
Yes. And they went on to say, this is just above G, as for the foster carers who are members of the appellant, there is no evidence that they receive any remuneration at all apart from the allowance and the retainer fee. Based on this limited information, we consider there's force in Mr. Collins' submission that, at least in relation to the FCA before us, the arrangement does not appear to be one representing remuneration for work done. However, there are insufficient facts for us to be able to determine the issue. A determination whether there's an employment relationship will involve a multifactorial analysis, including whether there is remuneration for work done. And of course, that wasn't analysed in the respondent's decision, which was based on the question of contract. So, although they look at the position more generally for foster carers, the decision in the end looks at the evidence in this case. And that must be right, because although for many reasons this case might be seen as something of a test case, it's not a judicial review of the system. It's an appeal against a decision of the certification officer in relation to this union, which can only be decided on the basis of such evidence as was available.
Well, hang on. Surely the purpose of this candidate union is to represent foster carers generally. The fact that the founder members, so to speak, are work for local authorities that only pay allowances is neither here nor there. If they wanted to represent, which is no reason to suppose they didn't, foster carers who worked under arrangements where they got a fee as well. And if those ones were workers, then the purpose of the union would be to represent wholly or mainly, well, actually there is a problem then, because you wouldn't know, they wouldn't know.
My lord, yeah.
It's really messy. It just shows how deeply unsatisfactory it would be to have a distinction between foster carers who got a fee and foster carers who only got the allowance. Even and a fortiori, where we're told sometimes they get a rolled up payment which isn't described as one or the other.
My lord, I understand that hesitation and I understand the concern. But can I offer this perspective on it? Determining whether or not there is an employment relationship requires a consideration of what the relationship is, how it comes about, what are the various rights and obligations of the parties to the relationship. And of course, courts and tribunals are very well used to that exercise, and it often involves identifying whether payments are made, and if so, whether they're made as remuneration for work done under a contract. Because whether somebody is a worker or an employee depends in many cases on that. We then have cases where one says, all right, remuneration is paid for a different reason or subject to different rights and obligations, and Gillam is a good example of that, where the court found, well, the remuneration is there paid pursuant to statutory obligations arising from the holding of judicial office. And we say, therefore, while of course one can see in practical terms the reservation between saying, well, do we want to decide worker status on the basis that some foster carers receive payment in different ways than others, if we're looking at a question of employment relationship, one can't avoid doing that. And that may actually be an answer to why none of these relationships are actually properly categorised as employment relationships at all. Because,
Go on.
I'm so sorry, Mark.
There you go.
Even where there is something which looks like a wage work bargain, if I can put it that way, it can look like it without in fact being it, the judge example being one of those where the office is what categorises it. Here we have what the court in Strasbourg might call forget the word now, special circumstances or special features of the relationship which might take it outside the scope of Article 11. We would, I'm sorry, do I look?
Well, I will say it now. Is this one where, I'm not quite sure whether this is what you're saying, but tell me whether it could be, even if fees are paid in the majority of the cases of the people who the union wants to recruit, you would say that is part of your argument that the fact that many foster carers don't get fees at all helps to characterise the relationship for all foster carers.
Yes, because it explains what the relationship between, Mr. Cooper talked about a triangular relationship, and even before corners to it where we have an agency appearing on the scene as well. But the crucial relationship of all of this is between the foster carer and the child. And while there may be statutory entitlement to allowances, and there may well be an incentive on a local authority to offer payments on top of the allowances, the relationship which is at the heart of all of this is between parent and child. And if I can give just one example
you say that. I mean, that's, I think, right if you're looking at the nature of the service provided. It is not necessarily right if you're looking at it in contractual terms. I mean, there's a statutory obligation. The child's interest is paramount. That permeates the Children Act. But we're looking at, if you like, the legal and contractual structure which underpins and surrounds that. I mean, that's quite different. Here we have someone who's a delegatee performing a statutory duty on behalf of somebody else.
And the starting point is to decide whether that relationship which is set up, that delegation of certain responsibilities by the local authority, it's partly delegation. Some of the role performed by the foster carer doesn't simply arise from delegation of the local authority, which has a requirement to provide things like accommodation and basic needs, if I can put it that way. But much more what the foster carers provide, of course, is the loving home, which is the real key to all of this. The example I was going to give your lordships was what are described as the kinship carers, grandparents, aunts and uncles who take in children whose parents, for whatever reason, aren't able to look after the children as they would like to. Those individuals, there was discussion yesterday about working on the basis of altruism. And my lords have seen already the suggestion that the recruitment as foster carers really, for the most part, seems to turn largely on that rather than financial incentives, although financial incentives appear to be relevant, at least partly, to retention. It's a wholly different sort of set of circumstances which explains the rights and obligations of the foster carers in our submission. It is so different from those who do, no doubt, an equally wonderful job working in a workplace for children who are in children's homes, for example. It is so different that one cannot sensibly characterise it as an employment relationship. And what we'd suggest is that, my Lord Justice Green identified a concern a couple of times yesterday along the lines, well, it can't be right to say the less you're paid, the less protection that you have. And that's not what we're talking about with this sort of analysis. It isn't the amount that is paid which is important. First of all, we look at whether anything is paid. If so, if there is, we say what's the source of the obligation to pay and the right to receive payment. And just to follow my Lord's question about the less you're paid, the less protection you have, that is a fact of some circumstances in domestic employment law. So a volunteer working in a charity shop can't bring a claim for unfair dismissal in the same way that a colleague who is paid under a contract of employment to do the same work might be able to. not because the employee is paid more or paid something, but because the payment is a feature of the relationship between the parties, and it's the relationship between the parties which gives rise to our ability to identify which rights the carer retains.
I wonder if I just, on that point, as we did development of it, one gets the impression from reading the Fostering Network report, which has a very great deal to say about fees and employment, that and there was, I think, a survey of nearly 4,000 foster carers, that they take the view that it really is because of their prior legal status, I suppose it follows from W in Essex, that in fact that's why they are badly paid. That might be the case in the domestic context, but if one's looking at it in the context of Article 11, it's a bit difficult to say if it's the case that W has really led to their bad pay over the years, 20 years plus. You can then look at the bad pay and say that's a defining feature of the relationship for Article 11. And that's perhaps reading too much into the network report, but there's a strong sense that they say because we've been treated as non-employees, we've been badly paid.
Two things to say to that. Neri says that the pay isn't a problem, and I can take your lordship to the reference in due course. He says once you take into account tax breaks and so on and so forth, that they're not underpaid.
None of that is really analysed in the judgment. That's really what it comes down to.
Well, that's because the judgment doesn't have to grapple with the question of whether they're paid well or badly or otherwise. Those are ultimately questions which are a mixture of political and market forces, if you like. So that the government and or local authorities have to take a decision as to what is affordable and fair and will achieve the ends that they need. There's a market forces element, because if we want to provide the necessary care to these children, if recruitment and retention were to turn on fees, then that would be an important factor in that. But those are not questions which give us answers to the problem of what the legal status of the relationship between the parties is. They're questions for the Secretary of State and the local authorities and for those campaigning on behalf of foster carers. But the structure of the relationship is what we are interested in to determine whether this is an employment relationship. If it isn't, then Article 11 is not applicable to this problem. I just wanted to add that into what Mr. Cooper submitted to you yesterday.
Just remind me, a factual thing is slipping out of my mind, that allowances are set authority by authority. They're not national, is that right?
There is, there's a, I want to get this right, and it may be that I'll get it right better after lunch. I think there's a minimum threshold. There are minimum standards, if I can put it that way.
The minimum standards actually have numbers attached to them, is that right?
I'll have to check my law, I'm so sorry.
Okay, well, we'll check over them. We can probably see that for ourselves quite quickly. But
Mr. Moreto, I'm sure is taking a note. I'm grateful. The main topic which I need to address your lordships on is that of justification.
Yep.
And the first thing to observe is that it's not enough in order for the appellant to succeed that this court might reach a different view from the EAT, as my Lord Justice Green's already identified. We're not rehearing the assessment of proportionality and justification here. You are concerned with whether there's a flaw in the reasoning or a gap in logic or a failure to take into account a relevant factor. I'm paraphrasing some of the authorities we cite in our skeleton that I won't repeat. And when you conduct that assessment, two preliminary features of the EAT's judgment we invite you to bear in mind. Firstly, Mr. Cooper's addressed you on the really very limited evidence available to the EAT in terms of that which was presented by the appellant. So they can only make findings as to the circumstances of the union on the strength of what they're told about it, which was not very much. Secondly, as a general point, and I know the court will have this well in mind, we invite you to bear in mind the expertise of the EAT in the context of industrial relations. acknowledging that the court that we have sitting today has some considerable expertise in that field also.
Two
of course.
thoughts. There are two lay members, but anything else?
That is a feature which is of plainly of significance as well. The purpose of having the lay members there is for assessment of real-world features, if I can put it that way, amongst other things, and that's partly what is being considered in a justification exercise. Now, the EAT rightly identified that the field with which it is dealing here, and in particular that is the field of industrial relations, is one in which the state enjoys a wide margin of appreciation. I'll simply give your lordships the paragraph numbers of the judgment. It's 103 to 106 where they cite Unite and UK and Boots and Vining. There's been some discussion over the last couple of days as to whether and to what extent the doctrine of the margin of appreciation as applied in Strasbourg has application in domestic law. The appellate skeleton suggested it had no application. We say that's wrong. And it may be that I can be brief about this, having heard comments from the bench this morning. We respectfully agree with the approach that's taken. The rationale for affording to government a margin of discretion is different for the international court than from the domestic court. The international court affords a margin of appreciation on the basis that national governments have a better view of their own populations than the international court, whereas questions of the margin of discretion in the domestic sphere are more to do with where one allocates decision-making competence between the legislature and the executive and the judiciary. But we'd suggest the proposition that the courts recognise that there are some areas of judgment within which the courts will allow deference to the policy assessments of democratically elected bodies ought not to be a controversial one. So Steinfeld, which is the most recent case saying margin of appreciation doesn't apply on the domestic level, cites Kebeline, which is the classic statement of recognition that there are some areas of political judgment where the legislature will be accorded a substantial margin of discretion, and we respectfully agree with what Mr. Cooper said, which is that the domestic authorities and the Strasbourg authorities, the examples Mr. Cooper gave, the same ones that I would have given, Boddington and Lawton, Unite and UK. Industrial relations is one of those fields where a substantial margin of discretion is appropriate, and it's a field in where the court should be cautious before intervening in relation to decisions of pretty high-level policy. And that's particularly so when we are concerned with provisions of primary legislation rather than decisions of the executive. No need to turn it up, but the reference for that is SG, paragraph 94, page 1505 in the authorities one.
Yeah, it's somewhat unrealistic to think that Parliament in 1974, which is where this provision originates, or maybe even further back than that, had in mind the special position of foster carers.
Sure, it didn't in 1974.
Or
And it probably didn't in 1992, to be fair. But it's for Parliament to decide when to revisit a statutory scheme and change it in light of circumstances as they develop in the field in respect of which it legislates.
That's always subject to the obligation on us to read down pursuant to the 1998 Act. Doesn't need to if the courts will do that lubricating exercise as it goes along.
No, of course, that's right. One of the things that Parliament does by the Human Rights Act is to confer on the courts a jurisdiction to consider some of the aspects of decision making and to decide whether they are compatible with the convention or not. But in relation to Article 11.2 and Article 14, where we are dealing with questions of justification, the boundary between what is within Parliament's competence and what is in the court's competence is not always fixed. And one looks at the circumstances, one looks at the context, to determine just how much discretion Parliament has and how far the courts will intervene.
Which end of the telescope are we looking at this through? Oh, if we look at it at the macro level, clearly trade union rights, social care rights are areas where the courts will probably naturally accord a proper degree of deference. If we're looking at it at the micro level, which is simply the restriction which creates the interference with this individual union's rights, yes, it's a very, very narrow issue. And it probably would be not quite so easy to say that when Parliament's never considered it before. Actually, it tracks that breadth of margin of discretion.
So it's, save that, macro decisions by states always eventually translate into micro consequences for individual circumstances. And so
we're quite close to the sort of bright line jurisprudence, aren't you? The macro decision is one which creates a general rule which may well be, let us assume for your purposes, defensible, but the way it plays out in a particular non-typical situation, if you ask to justify it in isolation, is not. I mean, this may be the sort of point that you're being made in your first pleaded justification.
I was about to say, I'm going to come on when I deal with legitimate aim to look at the aim of having a workable system of employment law, and in particular the system that Parliament has long relied on, which is allocating rights according to whether individuals are workers or employees or neither. And so, well, I would right to say that there's plenty of authority to say it's permissible for Parliament to draw lines which may result on hard cases which fall on the wrong side of particular lines, but there may be an interest, and there is often an interest in terms of certainty and understanding in having a line of that sort. So I was probably right to say that those two submissions are close to one another. Where I'm heading with all of this is to say, is there a difference between the way in which you approach justification under Article 11 and Article 14? We say no. Article 11 affords a wide margin to the legislator for the reasons that I've started to identify. The analysis of justification under Article 14, the reasons that I'm going to develop in a moment, is to be analysed on the basis that different treatment in this particular sphere is justified unless the court concludes it is manifestly without reasonable foundation. And I think what I need to do, and I'll take perhaps just a little more time than Mr. Cooper did, is to set out our position on the approach under Article 14, and that should hopefully aid me in explaining why we say the same approach to be taken under Article 11. I say a little more time, not much more, because I respectfully agree with the submissions that he made, and that the cases to which your attention was drawn are the important ones. My starting point is Lord Hoffman in Carson, a very well-known dictum that decisions about the general public interest which underpin differences in treatment are very much a matter for the democratically elected branches of government. Just for your note, it's paragraph 16 on page 766 in the authorities bundle. It is now clear that, contrary to what the appellant say in their skeleton argument, a manifestly without reasonable foundation test is not limited to cases about welfare benefits. Can I take the court quickly in the 5 minutes before lunch to a couple of the authorities which explain why that is so? Starting with Drexler, which is in Authorities Bundle 3, tab 72. Starts at page 2274. A decision of this court about school transport. In which the leading judgment was given by Lord Justice Singh, and if I can ask the court to start on page 2290.
Part of it is 76, isn't it, which has rightly been sidelined.
It's a section which runs from 70 to 76. I won't read all of it out in the interests of time, but it starts with the conclusion there's no binding decision of the Supreme Court which requires the Court of Appeal to hold that manifestly without reasonable foundation is inapplicable outside the context of welfare benefits. There's then a review of the authorities, which in the interest of brevity I won't go through, although it's helpful in our submission. And the important conclusion, my Lord's right, is that paragraph 76 is in fact the crucial point, not so much whether MWRF is the applicable test, it's rather how the conventional proportionality test, even if that's the applicable test, should be applied, given that the context is one in which a public authority is required to allocate finite resources and choose priorities when it comes to setting its budget, and is also a context in which the ground of discrimination is not one of the suspect grounds. And of course, we're a world away from suspect grounds in the present case. In this context, it seems to me there's no material difference between application of the conventional proportionality test, giving appropriate weight and respect to the judgment of the executive or legislature, and the manifestly without reasonable foundation test. And we respectfully agree. The very next case in the bundle is the JCWI case, to which you were also referred. And if I can quickly take your lordships to that. Page 2339, please. Paragraph 131 starts with the submission made to the court that the manifestly without reasonable foundation test is restricted to welfare benefits. And I won't go through it all now, but I would ask the court to read through to 141. And in fact, my lord, there's too much to read out given the time available. I won't do all of that. But can I ask the court to write down to 141, and then can I also flag up the conclusion at 51 again? This is at the top of 2347. Conclusion that whether seen in terms of the manifestly without reasonable foundation criterion or on a simple proportionality balancing exercise, the same approach is, or rather the same conclusion is reached. Can I just, I know it's 1 o'clock, one last case before I let the lordships go for lunch, if I may.
Of course.
It's tab 57. This is a criminal injuries compensation case, JT and the First Tier Tribunal, a case about what was known as the same roof rule, in which the Court of Appeal required to consider Article 14. Can I ask the Court within that to turn to page 1784, paragraph 86, is within the judgment of Lord Justice Leggett, as he then was. He refers at the start of that to two cases, medical costs and Alliance for Choice. He says both of those cases involve matters of economic or social policy which fell squarely within the area where the court will be slow to substitute its view for that of the executive or legislature. He says there's nothing in the step case, which is the origin of the expression manifestly without reasonable foundation and its application to our jurisprudence, happened to be a welfare benefits case. He said nothing about that case or other jurisprudence of the ECHR from which the manifestly without reasonable foundation test derives. No reason in principle or logic to adopt a different and special rule in benefit cases. And then a little further down he says, about 6 lines from the bottom, just above F, whether at the stage of assessing whether a policy choice strikes a fair balance, the hurdle for intervention is pitched at the level of manifest unreasonableness or something slightly less, is a point of some nicety which seems unlikely to make a practical difference in many cases. And we suggest all of those cases lead us to the view that the wide margin to be afforded to Parliament in the context of justifying an interference with Article 11 rights arising from decisions about industrial relations and the manifestly without reasonable foundation test in Article 14 cases of this sort are either the same or so similar that if there were a difference, it's small enough that it won't lead to any different conclusion. And, my lords, that's the basis on which this afternoon I'll address the court as to how to approach the question of justification.
How do you feel about timing? It's obviously unpredictable. It's even more unpredictable when you don't know how many questions we will ask. But subject to all of that, and roughly, how long do you think you're likely to be?
I indicated to my friend Krasnow yesterday afternoon, I'd done some quick maths while I was sitting at the back yesterday afternoon, which was that the appellant's side, as it were, had 7 hours. 7 hours takes us on our side of the room to 3:30. And it seemed to me it wouldn't perhaps be fair of me to go on beyond then. I hope my lords will be happy to hear from me for another hour and a half. I think it's
important, and in principle, of course, we are. I think we'll have to see how we go. Our experience is replies are very often unnecessarily long when they're given the opportunity to be. Intended, obviously, not to reiterate what was said first time round, but to deal with points that haven't previously been anticipated. And I would hope, therefore, that an hour between the 3 repliers will be sufficient, if not ample. And I see Mr. Krasnow looking relaxed about that. I can't tell. Well, Mr. Burton, in fact, Mr. Burton and Lord Hendy don't have an absolute right, I think, as interveners to reply.
I have indicated to them I'm very happy to share.
Yes, well, I don't think we will get in your way about that. But I think you probably have the whip hand about how much to let, what points to let them share on. But I'm sure you will exercise it.
Let me say, my lord, no, there'll be no attempt from this side of the room to silence Lord Hendy in terms of a reply.
No, I wasn't really seriously suggesting it, but I was just trying to think out how it would work in practice.
I think 3:30 is safe.
As long as it's going to work. Well, I think that is going to work then, just. Good. 2 o'clock.
Yeah.
That's what I had in my
You don't want to say
by 12 when I came in this morning, and you did. So
Well, I
that's
was hoping I should have by half 11. I should have at the start.
I'll drift it off when you
No, I
make the
don't
submission.
want to have trouble with DLP.
Yeah,
Suggestions that I can,
No, I will make sure.
but also like before I'm even repeating it, I should also assure you I have instructions to which make the points I did.
Yeah, no, of course. No. Sorry, I did.
Yeah,
The
no,
last
no,
thing I wanted to do
Yeah. No, I know you were.
I'm going to bring the wrong cup if I don't move it. Where do you want
I think.
it? Those are my ones.
Yeah, those are yours. Oh, yes, you picked
Shall I
up.
just put yours there? So
Yeah, sorry, I'll move on all the rest of my stuff. Get it all out of your way. Right your way.
Okay. Would you like to know if there's any particular things in my note that you won't be doing? Because I'll do.
Yeah.
Then I'll deal with it. The one point I would like to deal with it in the notes is
Oh, it is, yeah.
We need it, otherwise you'll suddenly go dark.
The other problem is that in the course, I've contacted my manager, and she seems to think that they're going to have a word with the judge that is supposed to be social distancing, but there isn't enough room. I keep telling them there's not enough room.
anyway, the point
Yeah.
is
Yeah,
this
I know.
point
The
here, the
thing
grants
is,
are being
Yeah, yeah.
listed. If I could
Yeah, please do.
and,
I mean, if there was
and
an
this bit
outbreak,
about
it could be
set
traced back to it.
Cooper going on and on, listen, section
Yeah.
one.
I mean, I just want to cover myself really. I don't want to get late. I mean, I told them. That's the end.
Reminds me we should, go back to them again.